Assalamualaikum and very good morning. My name is Muhammad Afifi bin Rahmi and with my other kid which is Chin Hui and Celio. We're from Group 6 for the tutorial Group 6 with Dr. Muhammad Zamri bin Zahid. We will present our written essay which is a critical analysis on the defense of Duress to murder and the applicability of the defense in Malaysia. Okay, for the first part which is introduction. Under Section 94 of the Penal Code, duress is not a defense for the offence of murder. An offence against the state are punishable by death. The express exclusion of the defense of duress to the murder cases has raised the dilemma of the accuser, who takes the other's life to save himself. How moral institutions strongly empathize with the accuser, threatened with harm more significant than his criminal conduct. The development of judicial decision on duress has attracted a view on the extension of the defense of duress to murder to make the defense less vigorous, more human and compassionate.
The reason why the defense of duress is inapplicable to murder is based on the quote by Sir Matthew Hale and also Blackstone, in which a man under duress with the peril of death and no option to escape unless he satisfies the coercer's demand, the accused in such a situation would rather die himself than killing an innocent. Some English cases that reject the defense of duress in murder includes Taylor versus Prince and also Regina versus Howe and Bannister. These cases reflects the court's attitudes towards the upholding of the fundamental doctrine to respect the sanctity of life, and as a consequence, it also imposed a high moral standard on humans when facing duress that would threaten their life. Another reason for the court to reject the defense of duress in murder is due to the risk of an increase in terrorism with its potential to force innocent persons to commit crimes, and this can be found in the case of Regina versus Howe, in which the court held that the high relaxation of the defense of duress to murder will become an easy defense for the perpetrator to escape from punishment. And the strong disagreement to the extension of the defense of duress to murder is shown in the case of Bott versus the Queen, in which, even though it is within the power of the court to extend the defense to murder, the extension will never be accepted by the court, as this will go against the fundamental doctrine as laid down by Sir Matthew Hale.
Criticism not to extend the defense of duress to murder. Lord Lowry specified in Art and Gods, whereby both courts and text writers have noted that the law on the matter is nebulous and ambiguous. Smith and Helden further indicated that duress is a general defense, but it does not apply to some form of treason, murder, and possibly not to attempted murder. This abstention rule to the defense of duress to murder has drawn criticism from many well-known writers on both pragmatic and philosophical grounds. On a pragmatic consideration, it is unrealistic to require a certain degree of heroism in murder cases under duress, while on the philosophical argument, the defense of duress would not deter people from killing in the circumstances with no realistic options. Degree of heroism. An ordinary individual should not be expected to have the degree of heroism to save another person's life when given a choice. According to Murrow, the court should not have the power to hold them to harsh moral standards for the person under murder offence. As opined by Lord Reed, it is inappropriate to require heroism as a condition of occupation. In certain circumstances, a person of decent fortune will not only submit to the trick but will commit the offence. Next, according to Lord Morris, it is unquestionably inappropriate to demand the acts of bravery or heroism in the serenity of a courtroom when such actions couldn't be reasonably have been expected of even the most steadfast and well-disposed individuals at the time of the decision. Listeners on the same stand stated that the explicit restriction of the duress defense in murder is a strict and unreasonable standard imposed on a human being to act at all times. Clearly, extending the defense of duress to murder solely illustrates the principle that the law should impose upon people only those obligations which they can reasonably be expected to comply with. Restrictions on the defense of duress will not deter people from killing in circumstances with no realistic options. There is a lack of evidence to suggest that the rule of not extending the defense of duress to murder will mitigate people from committing murder in a situation where they are truly in peril of their lives and with no reasonable alternative. With that being said, doubt on the inconsistency in the application of the defense of duress arises. Hence, it is arguable that this defense should potentially be raised in murder cases. Therefore, the existing norm may produce unfair and inconsistent outcomes because of these holes in its philosophical and practical applications.
For the extension of the defense of duress to murder, the inapplicability of the defense of duress to murder based on the rationale proposed by Hale has been critiqued for its absurdity that imposes a sunlightless duty on the accused as against the public policy that emphasizes the reasonable standard. It creates a moral dilemma of whether the law should absolve a person who kills the other to save his own life. Hence, judicial decision and scholar opinion propose some realization that allows the extension of the defense of duress to murder.
Commonwealth cases. In the case of Commonwealth and Viscout, the Massachusetts Supreme Judicial Court (SJC), relying on choice of evils theory, ruled that the trial court did not misuse its discretion, and duress was still an invalid defense to intentional murder. The court has cited Anderson policy reasons for prohibiting defendants accused of murder from raising the argument of duress. The judicial decision exhibits some degree of flexibility to the rationale that impose an imperfect and inflexible standard of conduct at all times, but not a reasonable consideration in particular situations, especially under threats. Next, some cases allow the defense of duress in murder. In R&C, the accused Antonio Berry allegedly made the claim that he brought a gun to a home, knowing Regina Cray would use it to kill a man named Vinci Day. Berry said that he was under duress since failing to follow Cray instructions would put his family's safety and his own in danger. The Court of Appeal made the decision by acknowledging that being under duress can be a defense for someone accused of being an accessory to murder. Another case is Hansen and Taylor. The court further made a general declaration that the defense might be admissible in circumstances of murder other than a principle. The court in both cases had also drawn the distinction between accessories and principles, whereby the term accessory refer to the all common law modes of participations. The degree includes the accessory before or after the fact, whereas it was the most immediate cause of the actor's real or who was present, aiding or abetting the principal in the first degree at the time of the commission of the defense. The application of the defense of weak murder cases, although it is not a total reelection of the defense to any murder cases, has reflected a trend in which there are some judicial approaches to ease the harsh hell rule.
Although penal code is said to relieve the harsh rule that totally prohibits the application of the defense of duress under a situation in which there is no any realistic option available for the accused person, by allowing duress as an affirmative defense under Section 2.09, subsection 1 of the APC. Under the APC, the term use or threat to use force against his person or another reflects that duress is not necessarily must be directed to the accused who committed the crime, but it can also be exerted on a third party. For the incorporation of moral involuntariness into duress, in the case of Regina versus Ruzic, the Supreme Court of Canada held that an accused person will only be criminally liable and be punished if the crime is done voluntarily under the product of his own free will and controlled body without influence by any external constraint. Extending duress to murder, the court has introduced the proportionality test. Firstly, the harm threatened must be equal or greater than the harm caused to the innocent person. Secondly, by applying an objective test, whether the accused person's response towards duress would be the same as a reasonable man when both are placed under the same situation. As such, if the accused demonstrate normal resistance to the harm threatened to him and caused no excessive harm to the innocent than the harm threatened to him, the proportionality element of the defense of duress will be met.
The applicability of defense of law perspective of Islamic law. Islamic law has a multifaceted stance against duress. Islamic law is rigid in some ways because it's meant to uphold particular divine human rights essential. Surah Al-Baqarah verse 256 tell about duress and Surah Al-Isra verse number 33 tell about murder. The majority of Muslim jurists have also recognized duress as a threat of harm to third party, but they could agree on who the third party might be. In particular, Hanafi and Hanbali jurists insist that whatever the type of threat, so if a third party is put in danger of dying or suffering serious physical harm, that is deemed to be under compelling duress. The victim response must be proportionate in accordance with the Islamic perspective on the various forms of duress. As a result, the level of danger depends on the damage done. The entire premise behind both compelling and duress is that there must be a direct correlation between the type of stress used and the committed conduct. In contrast, English law has disregarded the need for proportionality and still does to some extent. An Islamic perspective on the application of the defense of duress is very different from that of the MPC, but there are some similarities between them. For example, the Islamic perspective recognizes duress that can be directed to a third party compared to the English law that totally prohibited the application to murder. There is some argument on whether the third party under duress in the Islamic viewpoint consists of only family member or whatever it includes stranger. The emphasis on the requirement of proportionality between the threat presented to the accused and the accused response is also the same as the proportionality test under the moral involuntariness principle laid down in the case. Under the Islamic perspective, although the case another's life is prohibited if under duress, in which there is no alternative available to the accused, Islamic perspective shows empathy towards the accused under a still situation in which they have no choice but to surrender to duress while respecting the necessity of life. Islamic perspective also show understanding to the person who takes another's life at such time and this under duress, which render them with no realistic choice.
As a conclusion, we will suggest a certain degree of flexibility over the defense of duress to murder based on three grounds. First, the absolute prohibition of duress has imposed an unreasonable high duty exceeding the ordinary average human standard. Secondly, the restriction on the application of duress in murder is ineffective to stop murder in case there is no realistic choice available to the accused person under duress. Third, the restriction has gone against the principle of actus me in victo non est mens rea. While suggesting duress to be an affirmative defense in murder, we also suggest to apply the traditional and also the modern rules when accessing the facts of the case so that this defense will never become an easy defense for the perpetrator to escape from punishment. The traditional rules includes: first, the threat of death needs to be imminent, persistent, and extreme. Second, there must be reasonable fear of instant death. Third, the defense is inapplicable when the accused voluntarily places himself under the threat of another person. Fourth, the accused need to show a normal resistance to the threat by seeking help to escape from the threat. For the modern rules, that includes the proportionality test, the harm caused by the accused person towards the innocent must be equal or lesser than the threat he faced by him. Otherwise, the defense does not justify the accused person's act by contending his act is to save himself from the threat, while the harm caused to the innocent one has exceeded the threat faced by him. With such, by allowing duress as an affirmative defense to murder and at the same time applying the traditional and modern rule when accessing the facts of the case, it is hoped to relieve the harsh rule of the restriction of the application and also at the same time to make the law more humane and compassionate towards the accused person under duress.